Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Hey all, I thought I'd share with you what I am reviewing right now. It's an informal continuing legal education practice that I do to keep myself up on case law and things that we don't actually often touch on because so much of what governs what we do day to day is the Social Security POMS, POMS, HALEX, HALLEX, the SSRs, which is the rulings, and the acquiescence rulings, and things of that nature on a day-to-day basis. But so here is Adriana's a recent, only a few days ago, she put this out there. She dissects a lot of cases that come through the circuit court, and I'm sure she would do higher as well. But I tend to see the circuit court, and this one happens to be the Fourth Circuit. I do probably work in all circuits, although I'm located in the third. And all of them are important, no matter where you are in the country. While your circuit may hold something different, oftentimes they are very similar. So it's just that one, sadly enough, one circuit can cover the states in that circuit, and the rule could be tweaked a little bit differently than what it might be over in your circuit over there. But oftentimes things are the same. And I think sometimes one circuit's reasoning might influence another circuit when that issue comes before them, where it has not been before them specifically before. And I would imagine that they review what the other circuits are doing before they make a decision. So this one is about substantial evidence. And this has to do with, everything we talk about is building your evidence, 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 evidence. And it generally, the foundation of the evidence by law is your medical evidence. But of course, there is other evidence that can be supplemental to that. It just cannot replace what is needed with the medical evidence. And of course, if it contradicts the medical evidence, it's probably not going to hold a lot of water either. But this is good. This is in the Fourth Circuit. So it looks like Scharbrough versus Commissioner O'Malley. It's always against the commissioner, guys, no matter who the commissioner is. And they come in and go over the years. So really the name of the commissioner is not particularly important because whoever would be in there, this lawsuit pre-existed that. In this case, they affirmed the ALJ's denial of Scarborough's application for disability benefits. So they are agreeing with the ALJ and not agreeing with the claimant in this particular case. And it's about substantial evidence. And I'm just going to go through what Adriana says because she concises it up so well. Although she does attach the case too. So I can link you to this, I believe. I got this directly from her LinkedIn page, which is great. I used to get it from a private group I'm involved in concerning Social Security disability, but then you would not be able to see it. So I checked out her own page on LinkedIn and she graciously shares it there. So I will link it for you and you can go see what she has to say. But I'll go over the key points here that she shares. So the substantial evidence standard, and this is what the court emphasized, that it will not overturn an ALJ's decision unless it lacks support from substantial evidence, which is a very low bar. And that means even minimal relevant evidence can uphold the ruling. I often explain this to my clients, and it's hard to drive home. The ALJ can make a decision, and he or she has a lot of discretion on how he or she is going to weight the evidence and find what to be more credible than something else. And generally, it's always going to be, if it's a denial, it's going to be contrary to how the claimant and their attorney or non-attorney rep felt the evidence should be considered. But we don't overturn an ALJ's decision because we think more weight should have been given to something than he gave it, unless he lacked something that he was supposed to do before he arrived at the decision of how much weight to give it. Okay, so as long as there is substantial evidence, and this is not like a criminal case where it's beyond reasonable doubt. It doesn't even come close. It's not even necessarily a preponderance of the evidence. Now, I would say it's probably a preponderance, but it's certainly not clear and convincing, that standard, which is somewhere in between. And I know this all gets so vague and there's no specific numbers assigned to the chances or the statistics, but just know that a substantial evidence as a whole is not very much, okay? At least not to get a case dismissed by arguing that, and we put it in arguments, don't get me wrong, but that's usually not the basis upon which a denial is going to be overturned. So, unless it lacks support of substantial evidence, so there's no substantial evidence, then it's probably that argument at least will not be a grounds for overturning it. There could be other ones. So this is all about how to chew on the concept of substantial evidence. So the claimant, Scharbrough, the appellant, he had been complaining of debilitating pain, i.e. pain that would make him disabled, basically. And the ALJ found inconsistencies, and we talk about this in other videos, guys, between his testimony, his daily activities, which is probably found in his function report. You know, that one that everyone says is not important? It's always important. Super, super important. For representatives, attorneys, and non-attorneys, I don't know how any allow their claimants to submit a function report without legal advice and explanation on what these things mean, and digging through to get the most accurate responsive questions that will also show that they're disabled. Okay. So the ALJ found inconsistencies between the claimant's testimony, his daily activities, which are likely the things that he stated in his function report previously, and the medical records. And these inconsistencies are what in fact caused the ALJ to deny him, it sounds like. She says that they proved to be pivotal. So in evaluating pain, the claimant, Scharbrough, could it be Scharbrough? I don't know. So forgive me if I'm butchering that. He or she argued that the ALJ improperly dismissed his claims of severe pain, noting his lack of MRI evidence. However, the ALJ relied on less invasive imaging, and Scharbrough, again, I hope I'm saying that right, and his own denial of pain during critical periods. I'm going to get into this in 1 second so you can know how important this is. And it's also a big problem that's not even a claimant's fault oftentimes, but I'll talk about that in a second. And she says that this is a reminder that the nature of pain assessments and disability claims requires a nuanced evaluation of medical records and personal testimony. And this is why we nitpick on so much information before we actually draft up with our clients the report. So you have to have the answers to all the questions almost, in my opinion, before you're pumping out an application with a disability report and your activities and blah, blah, blah. Like, you want those things to jive. And because they're asked in different ways, people get confused and they sometimes answer something inconsistently or sloppily, I would say. But it's just natural. And that's what you have to get around, is not doing it the natural, quick, fluffy way, but being doing it very astutely and thinking long and hard and looking at all the other ways the question was asked, and are my answers showing the same picture of my realities? Okay, going back to that paragraph I just read about evaluating pain. So apparently, as he was saying from what I just read, the claimant was saying the ALJ is relying on the fact that he didn't have MRI evidence that would support the pain. So what this can kind of mean at times, MRIs, for instance, will show at times, let's say it's a back problem, it might show that a nerve is being abutted, compressed. Sometimes they use a variety of words, but they all mean basically the same thing. Impinged upon. And those findings support a finding of pain. Now, judges differ on whether that would be how severe and this and that. Okay. But when you don't have that and you just have degenerative disc disease or some narrowing, and the narrowing isn't maybe of the, spinal stenosis type or extent, maybe it's foraminal or something like that, that is not going to be considered something that would itself cause severe pain, because most people have that can work and don't have pain, or certainly not enough to not work. So it doesn't say here, and I could look this up in the case, but I'm not going to do it right now. Was there no MRI at all, or was there an MRI that didn't show, nerve impingement or cord compression, right? Two different things, right? There's either no MRI, which you don't have evidence to support you, or you have an MRI that actually spells something different, contrary to your, claims of pain. Now, as a private note, I don't think MRIs often show what exists anyway. And hear me out. Most people lay down for their MRI. Most of their pain when it's back is when they're standing. This is most people, guys, not everybody. So, as always, we're talking generalities here. And I think the stand-up pain is because of the gravity and the body weight causing more compression, right? So anything that is in between something that's going to compress is going to be more impinged upon when there's the gravity. When we're lying down, that closure is not there because the body weight and the gravity are not doing the same things, right? So that's just something that I've seen even radiologists discuss. And I've been seeing this for probably since I started this work. I don't think it was before that, because I did did a little personal injury work in my younger lawyer days. But I remember being really troubled by it, because when your client is in severe pain and this thing is not showing anything that even an outside third party can objectively say is, oh, for a fact that nerve impingement always causes pain, so that's troubling about the MRIs. It's just I always say, if you can get a stand up, if your problem is when you're standing up, I would try to get a stand up MRI versus a lay down. That's just in general what I think. I'm sure other minds can differ. So apparently, there was no MRI evidence. And like I said, does that mean no MRI at all? Or there was an MRI, but the evidence was not supporting of his allegation? It didn't support a basis for the pain. There was nothing in it to show what would cause pain that he complained of. And in that case, the ALJ instead relied on less invasive imaging and Scharbrough's own denial of pain during critical periods. That's the other point I wanted to get to. I knew there was two things in there. His own denial of pain during critical periods. This is another thing that can be very unfair to claimants. It's either unfair or it's not. If you have, you go to your doctor and you feel good and you honestly say you feel good, that's going to show up in the record. And that is something that, sometimes judges will grab hold of those, kind of cherry pick those days. But of course, if you have enough of those days, isn't it interesting that every time she goes to the doctor, she's not in the pain that she now claims she had? It might tend to throw a lack of credibility on what you're claiming now in terms of pain, since all those 10 medical visits you were fit as a fiddle and not in pain. However, the other alternative is that you do speak of pain and your doctor doesn't check the box, or the medical assistant who actually takes your, review of systems. That's your symptoms that you complain about. It's not medical evidence really of itself, only that you complain about it, which is still important, obviously. So if you have to know, if throughout your medical records, you have these periods of time when you are either not saying a word about pain or outright saying you're doing well, and hopefully you are doing well, because I'd like to see everyone be out of pain and be healthy and be able to live the life the way they want to live it, and, get their job and support themselves. But if you're not, you have to speak up. And it would behoove you, particularly if you don't have an attorney, to who would be looking at your records, you know, throughout, to look at your own records. In the doctor's progress notes, which is kind of like the report, the oral report, does it say that you complained of XYZ? If it's in there, on appeal, for instance, let's say there is well, this guy lost an appeal, so apparently there wasn't. If there is a ton of complaints of pain and the ALJ just cherry picked the days where there's no mention of pain when you went there, whether it's because you said it and they didn't write it down or check the box in the computer, or if you just didn't express it, but there's 10 times more where you did, that could be cherry picking, and it could be something you could perhaps argue on appeal that, you know, he said there was no minimal complaints of pain, and he listed 4 times that there was no indication in the record that I was in pain, but here's 20 times, you know. And as we know, you know, medical records sometimes don't record what we say. Okay, so that's that paragraph. Going on, the other thing was conservative treatment. The court backed the ALJ's characterization of Scharbrough's treatment as conservative, noting his use of pain medications, heating pads, and orthotics. This is important for practitioners, that would be me, as the characterization of treatment methods can significantly affect disability rulings. Even pain management therapies, if seen as conservative, may weaken a claim. This part is troubling because we are encouraged to follow conservative treatments before we do anything overly aggressive, such as surgery. That's not a conservative treatment, right? So when we're doing physical therapy and we're on pain meds, now, personally, I don't think narcotic pain meds is conservative treatment. I know it probably is, but I think so many people are concerned about using narcotic prescription medicine in this day and age, given what we know about it now. This is one of the toughest things, I think, that we sometimes have to consider. In any event, the other things they mentioned, of course, were the heating pads and the orthotics. Yes, those are conservative. And they're also, well, the pain medications are confirmable. And by the way, the level of pain medications, like if you're on a high dose, low dose, that's going to make a difference too. And again, that's not to suggest go get the highest dose you can. Like, that's horrible, horrible. But you just have to know what the visuals will look like. So if your visuals on, you know, and when I say visuals, I mean the evidence and how it might be interpreted on pain medications, if that's low end for someone complaining of severe pain, then you're also going to want to, then you want to be stronger in other areas, because you got to outweigh that somehow. You know what I mean? Like whether it's a lot of PT, or maybe you are concerned about pain medications and you are, you know, maybe addiction runs in your family and you don't want to become a statistic, whatever it is. I would make sure that that's well reported to your doctor, and that it shows up in your records that you discussed that you do not want. You're fearful of the repercussions of, you know, opioids and narcotics and such. Really, really important. And whatever other, if there is surgeries, which some people don't want to have because they've had it before and it didn't work and it made them worse sometimes, or it just didn't help them, and it is a risk, right? Surgery is always a risk. If you are a candidate for surgery, and, you know, I would try to get out a firm number from the doctor, like, doctor, I understand no surgery is 100% sure. So what are the odds of this improving me? And if you know the odds and you think they're very poor, given the risks, you know, express it and make sure that that's noted, that, you know, the low level of success in this surgery has the patient concerned that it might not be a good idea safety-wise. I mean, whether the doctor will put that in there, don't know. I don't know why they wouldn't. It's just the truth. But you can also try messaging your doctor if the topic of surgery has come up and you don't want it, and you have a really decent reason aside from the inconvenience of surgery. Because honestly, if something's inconvenient, it just means that your pain isn't really that significant. to warrant it. I mean, when they mean severe pain, guys, they mean severe pain, not the aches and pains that we all kind of push our way through. So I would, if I was going to say no to surgery, and I don't know for sure it's in the record, and I would probably get the records if I were you, I would message the doctor in a nice, in a nice way and just say, hey, doc, I just wanted to reiterate why, my reasons for not doing the surgery. And if any of these change because of the, medical discoveries, or you think the safety profile has changed or the success profile has changed, I'd really like to, go over it with you again so we can talk about whether that might be best for me or too much of a risk in your opinion. And that just will go to show that, it's in there that you discussed surgery and that you had reasons for not wanting it. It did not have to do without severe pain. It wasn't an admission of not severe pain if you're having severe pain. Okay, we're getting towards the end, guys, I promise. Daily activities adds evidence. I always think of this as the function report. But daily activities can show up in medical records too. If you tell your doctor that you went skiing 2 weeks ago, in the Poconos, there's a good chance it's going to show up in your record. So if you're doing that and you have a claim that involves physical problems, that's probably not going to work too well for you. Okay. So the author, Adriana, says, one of the strongest factors in this case was Scharbrough's own functional reports and activities of daily living, which included attending church, doing laundry, and cooking. Now, guys, I have videos on almost, if not all the questions on the function report, almost all of them, where I'm like, listen, if this is your answer, but you also do this, you need to really specify and be detailed. And that is true of doing laundry and cooking. I know specifically I talk about those. People get very, very sloppy when they answer these questions, and they look like they're the happy homemaker and can be a professional housekeeping for a hotel. So you have to really make it clear that if you do those things, how bizarrely you do them, how infrequently, or how piecemeal it is because you have to take so many breaks, right? Okay. The ALJ found that these activities of daily living were inconsistent with his claims of excruciating pain. And that's what I'm getting back to again, that we were just talking about. Excruciating pain, particularly if you say it's constant, is not going to be something consistent with you even doing your own laundry. You just wouldn't. You'd either be dirty boy or you'd have someone do it for you. Unless, and again, sometimes people will take, and this is, I hear it all the time. In fact, I've seen it in my own household at times when someone's been injured. You take your pain med, you have an hour perhaps of being able to do some mild stuff to, keep the roof over your head, which includes doing laundry. And they might start laundry. And then the next day, after, the hour after they take their med, they might finish the laundry. But that's the kind of detail of how you don't do it like a normal person because of your excruciating pain and because you have to have this pain med first, blah, blah. And that's only that window of time you can do it. So it's broken up. In my opinion, guys, the Adriana put, underscores that the need for careful preparation when submitting personal activity reports and disability cases. Thank you, thank you, thank you, Adriana, because so many of our colleagues refuse to assist their own clients with the function report and the work history report. And they say they don't have time. Well, guess what? Then you're in the wrong line of business. I know we work on very trim margins. I'm very familiar, but you can't be taking the case if you can't do the job. I mean, there's discussion about that being malpractice. So, you have to buck up and do the job right if you're going to take on the client. That's all. I mean, if a client doesn't partake in the function report and you can't get them to, well, then that's a whole different story. But, that's very rare. They're usually very grateful for the help and making it done right. And they see the questions in ways they didn't see it before. And they know what things they want to include now that are relevant and helpful to their claim. Really, really important, guys. So, okay. All right. So she kind of sums up conservative treatments, especially in cases involving chronic conditions, need to be carefully framed to avoid undermining the severity of the client's condition. Yes. And by the way, how they're framed, guys, is how it is presented from the onset. from the application. This is why I say if you can get an attorney or a good non-attorney rep before you apply to take the whole process and have it done properly, because this framing needs to match up with the framing that they're going to do later to set up this case and have everything properly shown. And if you left out things that you should have put in the beginning, you just have a misframe here. And things are now going to be inconsistent. Well, he didn't say that back in 2022 when he applied. He's just saying it now. Not good. Okay. I totally agree with her on that one. Always evaluate whether there are stronger diagnostic tools like MRIs available to back pain claims, or be prepared to address why these were not used. Yes, yes, yes. So this would also drive home the point. Some people go, oh, well, I had x-rays. I'm like, yeah, and they were pretty innocuous. Yeah, you got some degenerative disc disease. So does everybody. Everyone over probably 35, maybe even less. MRIs show things that x-rays do not show. If you have numbness, tingling, and things like that, you're claiming them isn't really medical evidence. That might be something more like a EMG, nerve conduction studies. I mean, you're going to talk to a specialist and get a specialist to prescribe, order the appropriate diagnostic. And if you know of something that should be more, like if your doctor's sending you to x-rays when you still have this, sometimes you have to be your own advocate and say, doc, I really think I need an MRI. This is the scuttlebutt I'm hearing, from a diagnostic point of view. So sometimes you have to really, and then of course, a whole nother issue is insurance. I get that. Sometimes the insurance will make you do some things before they'll let you have an MRI, such as physical therapy. So sometimes even if you don't want to go to physical therapy and you don't think the physical therapy is going to help improve your condition, you still do it. Okay. She sums up that the case reaffirms the challenges claimants face in overturning Social Security denials, but also serves as a guide for future filings. We must focus on consistency in evidence and ensure that treatment methods are properly contextualized in terms of their impact on daily life and work activity. There's so much. This is a really great, I mean, she always does a fabulous job. Summing it up. So yeah, it's great. I truly appreciate. And it looks like as of now, the case is unpublished. So we don't even know if it's actually going to be officially published. But I will share the link to her thing if you want to read it. The case is linked to it. So, all right, that's it, guys. Substantial evidence and the consistency of the evidence you have, particularly for things like chronic pain and chronic impairments that are not really, if you don't have the strong diagnostics that really spell out, and that's not where you stop, by the way, once you get that. That's just the strong foundation. Then you have to get everything else, and your ADLs, function report answers, have to kind of be consistent with what you're claiming. And, and all those little tidbits of information found in your medical records when you're telling the receptionist while you're killing time waiting for your doctor appointment to start, that you had a great time in Europe. All right. I'll talk to you guys later. Great case. Thank you, Adriana. Bye.